SJC-11337, Commonwealth v. Larry Nelson.
Yes, counsel, let's begin.
Good morning, Your Honors. Leslie O'Brien for Mr. Nelson. Mr. Nelson argues that he was entitled to the manslaughter instruction that he requested based on heat of passion occasioned by reasonable provocation. I suggest that the issue whether he was entitled to that instruction hinges in large part on one question. And that question is whether the jury had the power to credit the defendant's statement that he was attacked with a knife and received the serious wound to his hand during that attack, whether they could credit that even if they discredited his statement that this occurred during a mugging. And I'd suggest to the court that clearly the jury has the power to do that. The jury has the power to decide what evidence to believe and what evidence not to believe. So they could surely have credited Mr. Nelson's statements that he was assaulted with a knife, that he raised his hand to defend himself. He made that statement at least 4 different times, described to 3 different police officers, raising his hand to defend himself against an onslaught with a knife and receiving these horrible injuries across his hand. So I'd suggest that since the jurors had the power to discriminate, to decide that possibly these were defensive injuries.
Wait, I'm not following you. I thought the defendant reported he'd received the injuries during an attack, that some folks attacked him. You're saying they could have believed just a part of what he said.
Well, exactly. I'm saying that the jury, just as the jurors can believe part of what a witness says and
Yes.
reject the rest of what a witness says.
But it's just so I'm clear, his report that he had received the injuries was actually that he had been attacked by some muggers or something like that.
That he was attacked by a mugger. There are about, yes.
In Cambridge.
Yes, in Cambridge.
Okay.
There is, in one of the statements in the hospital records, which is at page 28 of my appendix, he simply says he was assaulted with a knife. In the remainder of the statements, there are at least 5 in the record, he does mention the mugger. But I'd submit to the court, and I rely on a case that's cited in the prosecutor's brief, where the court stated that the fact that the defendant denied stabbing the victim did not by itself relieve the judge of giving a manslaughter instruction if other evidence would have warranted a conviction of manslaughter. And that's Commonwealth versus de Armas, which is cited in the prosecutor's brief.
I appreciate the statement, the principle that juries can pick and choose.
Yes.
But is there no limit to some basis of reality? His testimony is that on that afternoon, across the river, almost in maybe Somerville, maybe Cambridge, he gets into these, a fight in one place or another. This is happening in Roxbury.
Yes, but I think you also have to look at the fact that the jurors, in fact, did have concerns that this was a defensive injury received at the hands of the deceased in this case. They asked that question. If I want to be accurate in stating the question, but it's to the effect that if there's a defensive injury, if the assailant or the accused receives a defensive injury, does that affect the degree of murder? So you can see that this is something that the jury was concerned with. They were concerned with it to the point where they halted their deliberations and asked that question. So unless the court is going to say that the jurors didn't have the power to believe that this was a defensive injury, if they rejected the entirety of Mr. Nelson's story, then there is evidence that this was a defensive injury received while Mr. Nelson was being attacked.
Let's assume the defendant has said nothing as to what happened. Is it your view that the injuries by themselves are sufficient to warrant a voluntary manslaughter instruction?
No, it's not. I don't know in another case whether that might have been a feasible argument, but here that's.
You're not saying that when the medical examiner made the comment that it was consistent with defensive, that wouldn't be enough in and of itself?
I'm not sure that would be enough in and of itself, Your Honor. I think that the defendant's explanation, where he says on at least 4 different occasions, I raised my hand to fend off a knife attack, I think that when you get that in combination with the medical examiner's testimony, that what he's describing is consistent with the injuries that he had, when you get those 2 things in combination, now you have a very strong case for provocation. And add to that the evidence that the provocation was by the deceased in this case, because I don't think that there's any...
There is zero evidence from anywhere about anything that the deceased did. I mean, you've got to make that up out of total whole cloth, don't you?
Well, Your Honor, if the jurors believed that the defendant was defending himself, if they believed that he was only in a violent confrontation with the deceased, and they believed the medical examiner's testimony, that was evidence of reasonable provocation. It's not what the defendant said, and that's what the ARMA stands for. It's not what the defense was. It's the evidence that the jurors heard. It's what the jurors could have believed and derived from the evidence. That's what decides whether they're...
What's the link between the victim and the defendant's defensive wounds?
Well, the link is that, and both, I don't think there's any conflict about this at this stage. And I realize at the trial stage, the defendant was saying, I didn't stab the victim, I didn't do this, I wasn't there. The appeal is obviously a different matter. The defendant's position at this point was that I should have received the manslaughter instruction that my counsel properly asked for at the conclusion of the evidence. And there's no conflict between the parties about when and where the violence took place. The violence took place in a very violent confrontation between the deceased and the defendant in the apartment of the deceased. So if for the jurors to be concerned that there was a defensive injury here, they're concerned about they found the defendant guilty of the crime, of the homicide. They're concerned about this, what they perceive to be possibly a defensive injury based on both the injury and what the medical examiner had to say. So that when you combine that with the fact that neither side is contesting that this occurred in a violent confrontation with the deceased, that is reasonable provocation. I think it raises the point, how high really does the bar have to be before a defendant is entitled to have the jury make the decision? He opted for a jury trial. Why shouldn't a properly instructed jury have been permitted to make the call? Why was the call the judges and not the juries? He opted for a jury trial. There was evidence of reasonable provocation. There was evidence, and I'd point to the fact the prosecutor,
Well, the evidence of reasonable provocation is only,
if the jurors believed that it was, I'm sorry, Your Honor, I interrupted you.
no, I was,
Excuse me.
That's fine. I was
Anticipating.
just trying to think, but, and you probably anticipated correctly. No,
Yes.
it's only the number of wounds on, I mean, I don't know why the number of wounds on Mr. Stroman, is that the name of the victim?
Yes, it is. That's the deceased.
The number of wounds that he suffered tells you anything. So you've got the number of wounds that he suffered and where they were, and you've got the wound to your client, which the only evidence is happened across the river. And so don't you need some affirmative evidence that there was provocation by Mr. Stroman to even get here?
But that's not the only evidence that this happened across the river, Your Honor. The evidence presented at trial was pretty strong, and I'm submitting this and admitting this in the appeal. The evidence was very strong that the injury, however it was received in the doorway there in this violent conflict with Mr. Stroman. So the question becomes, I mean, it's...
You say the evidence is strong because...
Well, there was the defendant's blood. There was DNA found in the apartment. There was strong evidence. We're conceding at this point that he was in the apartment, that he was in a very violent confrontation with the deceased. But he repeatedly said that he threw up his hand to defend himself against a knife blow, and the medical examiner said that injury to his hand was consistent with that explanation, and even went on to say that, to describe how defensive injuries are looked at. She explained that instinctively a person in response to a knife attack will often put up a hand to try to grab the knife. And the medical examiner felt that was consistent with the defendant's explanation of how he
Did the
received.
defendant ever claim that the victim provoked him?
He did not claim that the victim provoked him. What I'm saying, Your Honor, is that from the circumstances of the case, based on the defendant's statement that he was attacked with a knife, based
By
on
muggers in Cambridge?
Yes, and I'm relying on de armas that it's not what the defendant says. It's not what the defendant says. It's not even what the theory of the defense is. It's the evidence that the jurors heard that entitles or doesn't entitle the defendant to a manslaughter instruction. And the jurors, their question made it clear that their verdict made it clear that they believed that the violent conflict was with Mr. Stroman, and their question regarding the defensive injuries, that they thought that there may have been defensive injuries sustained during the conflict with Mr. Stroman, because they're asking, does it make a difference between first-degree murder and second-degree murder if we think these are possibly defensive injuries? It was simply something. My argument is really that it should have been left to the jury. And I'd point out the Commonwealth also argues, well, even if a single blow, in arguing the nature of reasonable provocation, a single blow does not always give rise to reasonable provocation. In the cases that are cited by the Commonwealth, these are cases where there may be a harmless punch or a scratch to the face. In Rembazewski, there was some harmless punches by a 95-year-old man in Walden. There's nothing in those cases like these where the defendant was actually sliced across 4 fingers, his tendons, his nerves badly damaged. He would there was testimony that he would have lost the use of his hand from this injury. if he had not received surgery. So certainly, getting to another part of what's required for reasonable provocation, certainly this was the type of injury that would cause an ordinary person possibly to lose restraint, to reach such a stage of panic or anger or nervous excitement that he could lose his capacity for restraint and reflection.
But it's only reasonable provocation if it was the first blow.
If it were, yes.
If the
yes,
victim struck the first blow, and the only evidence of that comes from, well, you say, came from the defendant's description of what some kid did outside in Cambridge or in Somerville.
It comes from the defendant saying that he was being attacked, and that was
During
how
a
he
robbery.
received his injury, from the medical examiner's testimony, and from the fact that we know that the injury was in fact received in the conflict with Mr. Stroman.
Well, the principle of picking and choosing, I don't think goes to the extent that the jury can substitute. I'm just picking up where Justice Gantz was, that he was attacked by a kid in Cambridge. Forget Cambridge. He was attacked by a kid.
Yes.
He says that. How do they? I don't think you can substitute Mr. Stroman for the kid just out of whole cloth.
But really, that's not what de Armas said. And if I'm right that the jurors could believe that, and jurors clearly did believe that there was this violent conflict between these two men, the jurors were concerned that there was a defensive injury. They were concerned that at one point Mr. Stroman was the aggressor. And it's supported by, at the very least, by the statement in the hospital record where the defendant says, and this is on page 28 of my appendix, where he says he was assaulted with a knife, where the part about the mugger is omitted. The standard for
That's in the discharge summary. It follows on when he first presents, where he says it was after attempted robbery. So that's, who knows who gets the discharge summary? I think it's from the record.
But it's referring to his statement. It goes on to say that he says he doesn't have or didn't have any other injuries. So it's clearly, the one on 28 is clearly referring to Mr. Stroman's injuries.
And the full statement's when he first presented.
And
Sorry.
What consequence is there to the fact that the medical examiner testified that several of the victim's wounds, including the wound to his head and including the wound that nearly severed a major artery, came from the rear?
well, I'm not saying that nothing happened after the initial injury. I'm saying that the jurors could have found that the initial injury was at Mr. Stroman attacking with a knife. I'm saying that the jurors, I shouldn't say that they could have found that they could have reasonable doubt, because isn't that that's what is required? They could have had reasonable doubt that this defensive injury was sustained at Mr. Stroman's hand. That's what's required for Mr. Nelson to have had a right to the instruction on reasonable provocation. Not that he prove it beyond a reasonable doubt. It's in Commonwealth v. Carrion, the court states, a manslaughter instruction is required if on any view of the evidence, regardless of credibility, manslaughter may be found.
Could I turn you to the instruction that the judge gave to the jury, the response to the jury question?
Yes. I've stated that the response to the jury question was inadequate, in part because the judge simply did not answer the question. Whether the jurors wanted to know whether if evidence of a defensive injury could have any effect on first or second degree murder. I'd even suggest that this was a hint that the jurors were looking for a definition of manslaughter. But nevertheless, at the very least, what the judge could have said was, it's up to you. It's up to you whether that makes a difference. If I could just briefly touch on the Commonwealth's argument, which I also state was error. The Commonwealth argued that they could say that it was a reasonable inference for them to say, even though the medical examiner said that the wound was consistent either with a defensive wound or possibly slipping down on the knife, the prosecutors say it's a reasonable inference for us to say, no, it couldn't have happened that way. It couldn't have been a defensive injury. If that's a reasonable inference, Your Honors, if that's a reasonable inference, it's surely a reasonable inference for the jury to infer that that defensive injury was sustained at Mr. Stroman's hand, and that's what sparked this violence. None of this makes sense as an unprovoked incident. Something provoked this incident. The prosecution wants to paint it as an unprovoked incident on a 65-year-old man. It makes no sense. Thank you, Your Honors.
Thank you.
Good morning, Your Honors. May it please the Court, Teresa Anderson on behalf of the Commonwealth. With me this morning is one of the trial prosecutors, Assistant District Attorney Gretchen Lundgren. We're asking this Court to affirm the defendant's conviction for the murder, for first-degree murder for the death of Richard Stroman.
What do you say about the judge's instruction in response to that very interesting jury question?
Judge Fabricant properly instructed the jury and answered their question. She did not take away from their consideration the possibility of defensive injuries in re-instructing on first-degree murder and second-degree murder.
But it was hardly responsive to their concern.
It was responsive to their concern, but she couldn't directly answer their question in a fact basis.
You tell them it was up to them.
And she did, and she gave them the proper legal framework to decide how to consider what to do with that evidence, how it was up to them. She gave them the reiteration of first-degree murder, and she defined the difference being the elements of extreme atrocity, the factors for extreme atrocity or cruelty, certainly one of which, the defendant's mental state of indifference or pleasure during the killing that my sister points to, is the one that possibly could have been affected by the possibility of defensive injuries. It's not taken away from the jury's consideration.
She didn't say it's up to you. She just read the instructions again, correct?
Correct.
So it wasn't as if she began by saying, I received your question, and my answer is it's up to you, and now I'm going to read you again my instructions on first and second degree murder.
She says, I received your question. She reads the question into the evidence and then says, here are the instructions on first degree, second degree, and then continues with reasonable doubt, and then the jury's duty to find the burden.
I mean, it just doesn't seem to go to what they were asking, to me.
The jury's question, according to the law, does the possibility of defensive wounds on the perpetrator have any impact on the verdict of first versus a second-degree murder? She can't give them a yes or no answer because that would imply a version of events. It needs to be the jury's determination of how, and how is based on the legal framework of what are the elements of murder. What are the elements of first-degree murder based on extreme atrocity or cruelty? What are the elements of second-degree murder?
Well, it's a fair question because there was no self-defense instruction, correct?
No self-defense instruction whatsoever properly.
So what is the answer?
I think the answer that the defendant wanted to give was yes or it may.
Okay.
And I think that's what was given here. It was given that
No, she didn't say yes or it may.
in the legal framework, it is up for the jury's consideration.
Okay, but I mean, but the jury already heard the instructions that the judge gave
Yes.
before.
Yes.
And they still had a question.
Yes.
So put aside for a moment whether or not there was error in the judge repeating her instructions. What is the answer? I'm not quite sure what a judge should say to be truly responsive. If a judge, I mean, you can't say you may consider that as part of your self-defense issue because there was no self-defense.
but
It doesn't go to premeditation. Well, I guess unless you infer that the defensive wounds were inflicted first? I mean, it's a
No,
hard question.
I think it possibly goes to one of the Cunean factors, the defendant's mental state of indifference or pleasure during the killing. Does the fact that there's, and this is my sister's argument, the possibility that he had this injury to his hand so overcome his ability to then kill the victim with extreme atrocity or cruelty?
But that, I mean, if that's, let's just take you what you say. It goes possibly to that, and then the response is, let me give you all 7 of the Cunean factors, and by the way, jury, all you have to find is one of them. I mean, it seems to me it sort of takes you totally away from what you say maybe it goes to, the answer.
But all of those factors are for the jury to consider. Yes, it may go to that one, but you also need to consider the other 6 Cunean factors. You can't stop with just the one. You can't stop with just the possibility of this defensive injury on these instructions where the defendant was not entitled to a manslaughter instruction.
I mean, I gather that the defense alternative wasn't any better, which is you should answer yes or it may and then refer to your previous instructions.
And that's correct, correct. Because saying yes or it may, I think, imputes a fact. Yes, if you find this, it may affect something. And it doesn't give them the complete framework to analyze how, and analyze, here's first-degree murder based on extreme atrocity or cruelty, here's second-degree murder. Jury finds the facts, again, part of the initial instruction, and then applies the law, and here is the framework for the law. And if you were to find the possibility of defensive injuries, here is the law that you would then apply. And that's what she instructs on.
It doesn't say it that way, right?
No, but that's I think the calculus between the parties in answering the question is, this is what I'm thinking I will re-instruct on first degree and second degree. And that gives them the framework to answer their factual question.
Maybe the difficulty is the absence of another instruction that was requested and denied. I made a mistake earlier. I was focusing on a different page in the record. There is, despite all the other places where the defendant tells people he was robbed, that doesn't appear in the record from Mass General Hospital, where both the intake and the discharge, he apparently, or at least that's the only statement they have here, is this happened after he was assaulted. What do you say to that?
The defendant was not entitled to a manslaughter instruction on this evidence. The evidence that he was, in the light most favorable to the defendant, I think this includes this discharge paper and so forth, is that the defendant sustained an incised wound to his hand that was consistent with a defensive injury during the course of the homicide. And so even if you add in, and he was assaulted, and it was during the course of the homicide, that's in the light most favorable to the defendant, that's all you get. Again, I'm not conceding that there's any evidence that puts a knife in the victim's hand at any point. There isn't. There's no affirmative evidence. To be clear, no affirmative evidence that puts a knife in the victim's hand at any point.
Well, I mean,
But
you have the ME statement that the injuries that the defendant suffered were consistent.
by inference, in the light most favorable to the defendant, you do have 2 people went into this apartment, one is dead, and one ends up with arguably an incised wound to his hand that is consistent with being a defensive wound. The ME's opinion testimony is very limited. By saying it is consistent with a defensive wound, she can't opine on how he sustained that wound in any way, shape, or form. She doesn't provide and cannot provide testimony on how the wound was inflicted on the defendant or how the wound affected the defendant, which is the other part of the objective and subjective test that we need to show reasonable provocation, how this defendant was affected and how an ordinary person would have been affected.
Well, certainly an ordinary person, had that been the first blow, would have been reasonably provoked.
And here we're speculating on 2 things, the ordinary person and this being the first blow. Here we have the defendant.
It's really the first blow, isn't it? I mean, isn't that the issue?
Total speculation on the order and, again, how the wound was inflicted, even assuming that it was the first blow. This defendant didn't react as you might expect an ordinary person.
Why do you even concede that even if? I mean, there's nothing
I
to
don't.
say that it was.
Absolutely not. Absolutely. It was whole speculation. If we go into the field of speculation that this was the first blow, even then, here these defendants' actions don't show that he was overcome and that his response was irrational. His response was, after stabbing, again, assuming first blow, victim to defendant, and then 20 stab wounds, defendant to victim, and then rifling through his jacket, taking his cell phone, taking his wallet, making a cell phone call, and engaging in this campaign of deception from the very outset.
What was the defense, what was the argument, closing argument by defense counsel?
That the client was not present in the apartment, that the defendant, that these defensive injuries supported the defendant's version of events, that he was across the river, that the DNA and forensic evidence didn't put him within 20 to 25 feet of the victim, and that there was other missing DNA evidence, kind of a Bowden style, in addition
How
to.
did he square, he wasn't in the apartment with the DNA being only 20 feet away?
I'm sorry?
How did, in the closing, which I didn't read, how does he square the DNA evidence of 20 feet away, which is not at the location of where the decedent is, and I'm not there?
He squares it in that he never offers an explanation for why his DNA
Affirmative
is
claim.
there, just that it's not close to the body.
Was there,
And what about, did he explain how it was he had the victim's wallet, credit cards, et cetera?
No. There is a challenge to the credibility of the witness, Barbara Yoahu, who is the one who said that she found these items in the defendant's car. She entered into a cooperation agreement, and her credibility was challenged on a number of points. She made several statements and was impeached in several different directions there.
I can't remember this, but obviously he had a relationship with Mr. Stroman, and was there evidence that he had actually visited him at the apartment? I know not that night, but in other times during tutoring or,
I'm not
in
sure
the
that there
relationship?
was, and I think the defendant in his statements maintained that he had never been to the defendant's apartment. May have dropped him off on occasion, but had never been inside the victim's apartment. I guess I would also add in this case, that in addition to inflicting 20 stab wounds upon the victim, this victim was a 64-year-old man. This victim had severe physical limitations. And again, the evidence is not that he ever had a knife, and even if the injury was sustained in the course of this homicide, it was not, there's no evidence that it was the first blow here.
There was evidence, if I'm recalling correctly, that the victim had a gun collection.
Yes.
Knives, an arsenal.
Did he also have knives?
I don't recall if it was the same collection.
Had knives.
I don't recall. Kitchen knives and the guns.
It was a machete that was found, right?
That's what's described by the witness, Barbara Yoahu. It's not recovered. The evidence is that she saw it in the trunk after the defendant told her not to look in the trunk, after she saw the defendant place the bag in the trunk. She went and cleaned the car the day after, saw the blood, saw the then victim's cell phone and wallet came out of the glove compartment, and she opened the trunk, she opened the bag. She saw what she described as a large, bloody knife.
But one can infer from the depth of the wounds, the nature of the wounds,
Certainly.
that this was a rather unusual knife.
Certainly. Certainly.
And what meaning, what meaning do we give to the juror question with regard to Ms. O'Brien's claim that a reasonable jury would believe there was a possibility of a defensive wound here? I mean, the jury at least asked the question, so the idea had occurred to them. How does that go to whether or not there should have been a voluntary manslaughter instruction?
Two separate inquiries. The juror's question shows that they are looking at the evidence and they've heard the ME testify that the injury is consistent with being a defensive injury. And they've got the defendant's statements that they're they're considering the possibility of defensive injuries. And that's a separate inquiry from whether the evidence supported and the inferences therefrom supported a manslaughter instruction. Just because they're thinking about it doesn't mean it's supported and doesn't mean it legally mitigates a murder to a manslaughter.
And the defense attorney, I gather, in closing argument, argued that the Commonwealth had failed to disprove
Yes.
that those wounds were defensive.
Yes. And certainly entitled the prosecutor to not only to refute that argument, but based on the evidence she did, and argued that the wound was a self-inflictive, aggressive injury that the defendant sustained during the course of the stabbing. And that's based on more than just the medical examiner's testimony that it was consistent with a self-inflicted wound. That's based on the testimony I've outlined so far, in that there's other evidence that this was self-inflicted, the defendant's actions after the murder and so forth.
But isn't the argument of defense counsel that the prosecutor went beyond the medical examiner's inferences and essentially became an expert herself?
She did go beyond the medical examiner's inferences because there's other evidence to support the theory that it's self-inflicted, as opposed to, on the other hand.
But part of it was that the sheer force of hitting bone would have pushed the hand up, and is that something which a prosecutor can argue without medical evidence?
I suggest there was medical evidence, again, the depth of the wounds and so forth, and I'm not sure that that's exactly her statement. Certainly, plunging the knife into the victim 20 times, supported by the evidence, and the possibility that the knife would become slippery after a number of stab wounds and that one's hand could slide over the knife. I'd also point out the injuries to the defendant's hand were in a line. She compared the injuries to the victim that the medical examiner also testified were consistent with defensive injuries. And again, the medical examiner defines defensive injury as a wound to the hand or arm. Again, characterizing the wound as defensive gives no information on how it was inflicted, if it was inflicted in the course of defending oneself. And she says, this is my, defensive wounds are often seen on the hands and forearms. And when looking at the defendant's injuries, said, so these appear to be incised wounds of the hand. So yes, they are consistent with defensive wounds, but they may not necessarily be defensive wounds. It's on page 7, or transcript volume 7, page 33.
And I have not asked, when the Commonwealth found the victim, were there any knives on the floor, or were there any knives in the apartment, and any that had blood on them?
No, I don't believe so. I don't believe so. Maybe a pocket knife, but I don't believe, certainly not the murder weapon. There was a hatchet recovered in a search warrant of the defendant.
But there were none which had signs of blood on it?
No.
It's a pair of scissors.
And that, I believe the pair of scissors had the defendant's blood on it. The DNA from the samples taken from there came back to the defendant, I believe. I think the pair of scissors might have been in the bathroom.
Came back to the defendant or the victim?
The defendant, I believe.
There was evidence, I didn't know if you recalled it, that 9 of the wounds struck cartilage of bone, so that wasn't...
Yes, absolutely. And evidence, the prosecutor walked through with the medical examiner and pinned on a mannequin each of these wounds and described both the length and the depth in addition to the location of each of the wounds, and anatomically where they would have hit on the inside. Lastly, I'd ask this court to deny any and all relief under Section 33E. This was a vicious and unprovoked attack by the defendant against the victim. Certainly there was a motive for this murder, but we don't know. There is no evidence what it was. It's hard to believe that something like this can occur, and 20 stab wounds would be wholly unprovoked, but the evidence of provocation is none.
But I gather the argument was that he was trying to get money to get the legal seafood dinner for his girlfriend's birthday, and the person didn't come up with enough money.
There's a number of theories that we could speculate on the motive. The defendant made a statement, I think to Barbara right after the murder, that someone owed him money. When she asked what happened, somebody owed me money. There's some evidence that the victim withdrew $60 from the ATM in the moments before the murder. There's some evidence that the victim religiously played the lottery and scratch cards and may have gotten lucky. There's evidence of some prescription drugs. And again, so here we're wholly speculating on what the motive was. Again, hard to believe that there wasn't one, but there is no evidence that there was one. And so on these facts, where we have an unprovoked attack and the defendant's actions covering up this murder while the victim lay dying in his apartment,
I just follow up on something I forgot to ask you, and you've brought it to my attention. The evidence of the victim being the one who withdrew the money, Was that wasn't just using the victim's ATM? It was confirmed by him being on the video, the
There's
bank's
surveillance.
video?
Yes, surveillance video from the Stop and Shop.
And there's something that puts the defendant together with this. He says he ran into the victim at some point with his mother and gave him a ride home, but didn't go in.
The defendant's interviewed by the homicide detectives in
Right.
March of 2008
That's-
and makes a statement that he did see the defendant at some point at the Stop and Shop with his mother. And if the court has no further questions, ask the court to affirm the defendant's convictions and deny relief under 33E.
Thank you, counsel.
Thank you.
We'll take our morning break.